Hello, my name is Joseph McDaniel, and I'm a bankruptcy attorney in Phoenix, Arizona. I'm also required under the 2005 amendments to the Bankruptcy Code, which we bankruptcy attorneys generally refer to as the BARF Act, to let you know that I am a debt relief agency. Anyway, what kind of bankruptcy is the most common? Well, by far, Chapter 7. It's generally referred to as a straight liquidation case, even though in 97% or thereabouts of those cases, nothing gets liquidated. There are three other common sorts of bankruptcies. There are Chapter 13s, typically wage earner plans. There are Chapter 11s, typically for large corporations or rock stars. And there are Chapter 12s for family fishermen and family farmers. As a practical matter, here in the desert in Phoenix, Arizona, we have relatively few family fishermen. But on the other hand, since I see a good many unusual cases, if we have any here in Phoenix, Arizona, I'm likely to see them. Why are Chapter 7s so common? Well, for one thing, we're in the middle of a depression. For another thing, they are the most straightforward, simple, brief, and least agonizing of the bundle of sorts of bankruptcies. In a Chapter 7, in effect, the honest debtor says, I give up. I can't do this anymore. I have overwhelming debt. And the honest debtor then fills out a bunch of schedules and lists and petitions and stuff. And it all goes into the court. And those lists include lists of all of the debts and lists of all of the assets. Those lists must be complete. So, does a debtor list creditors that the debtor intends to pay back on the other side of the bankruptcy? Absolutely. Does the debtor list debts that the debtor knows will not be discharged, like most student loans, tax debts, alimony and child support? Absolutely. And on the other hand, does the debtor list all of their assets? Absolutely. And that's because, well, it's a crime not to list debts and not to list assets if you do so knowingly and intentionally. In the list of assets category, most of the assets stay with the debtor in most of the cases. Remember, 97% or so of all Chapter 7 cases filed during any given year are what are called no asset cases, which means that the bankruptcy trustee has reached the conclusion that there are no valuable assets which are not exempt, which are useful for liquidating and paying creditors. And therefore, the bankruptcy trustee has reached the conclusion, which is true in 97% of all cases, that the assets are either worthless, over-encumbered, or exempt. Worthless, we all understand. Think about the antimacassars, which are sort of doily things, that go on the back of chairs to keep the chairs from being injured by Macassar's hair oil. Okay, those are worthless. How about over-encumbered? Well, basically, that means you have more lien or more mortgage than you have car or you have house. And how about exempt? Well, there are exemption laws in every one of the states. Those laws differ by and large from state to state to state. However, the laws in most states are generous enough in any case that most Chapter 7 cases wind up being no asset cases. Now, is a no asset case an easy case? No. That would be nice. It's just a little easier than the rest. But we'll talk about that more as the days go on. Thank you very much.